Welcome to the Plant Grow REIT podcast.
Welcome back to Plant Grow REIT podcast. I'm Shane, and this is the first episode in the series we'll be doing called What Your Lawyer Wants You to Know. And this series will focus on the key challenges, frustrations, and frequently asked questions that professionals see every day in different areas of law and business advisory. And today I'm joined by Peter Gandolfo, fellow director of Aintree Group. And Peter has been a long-standing participant, or I don't know what you want to call it, and you can jump in at any time if you want to. Been a lawyer for a very long time and has been through the many changes within the industry, but particularly focused on commercial law and has a lot of insights into this topic. So welcome, Peter.
Thank you, Shane.
And yes, this will be an interesting discussion about different elements of commercial law that we can touch on that business owners and in general that people need to be aware of. So in terms of the first thing we'll cover, we have a lot of clients that it might be different families that join together to run it, to establish a business or to establish some sort of partnership to run a business, to buy property, whatever it might be. And they do it on a handshake deal. Now, from my experience being an accountant, that can be feasible and can work. But what are some of the traps or what are some of the things that people need to be aware of by you doing a handshake deal in terms of having something more formal documented?
Well, there's a number of ways you can consider that. One of them is you've got to count how many fingers they've got for a start, because a handshake can be useful,
yes,
or it can be quite useless.
Is it binding? Is a handshake binding, or can it be?
Well, for some people it is.
Okay.
But only if they know exactly what they're talking about at the same time. So just to give you a current example, it seemed like the Pakistanis thought the other day that there was a handshake deal in terms of what was going on in the Middle East. But it turned out that one of the countries didn't think that was the case and kept going. So there's one example of total agreement on the one hand, but nothing agreed at all. For any contract, you need to have certainty, and it's very hard to know for two reasons. What's certain, one of them is memory fades, and quite often you find that somebody who's in a position to make a decision down the track, that may not be the same person that made the handshake. Could be a representative.
Yeah, okay.
Now, that representative, Shane, could be some kind of successor in the business, or it could even be an executor or an administrator of an estate. So what are they going to do?
Yeah.
What do they look at? How do they make a decision?
Yeah.
And how fair is that to anybody? And the other thing is, of course, the person may not just suffer from a memory loss. It may be worse. They might be really unwell. And so there's nothing for anybody to look at to guide them to make a call on what was the original agreement and how is it supposed to be implemented.
Okay.
So it's actually really built on sand. It's not strong enough to be able to help people, including advisors. So you as an accountant, you're told that there's a handshake. You're told this. You may not be told the full story.
Correct.
That's inefficient. Even if it works long term, it's going to cost you more.
Yeah, and also someone's opinion of or understanding of what was discussed in the contract, the verbal contract, might change over time too. Absolutely. So, okay, so
but more to the point, it's not going to cover the contingencies.
Yeah.
So because you go in generally into an agreement saying, well, it's all going to work. Everything's fine. We both know it's going to work. We both may actually have entirely different views about how it's going to work, but that isn't even discussed.
Yeah, okay. So verbal agreement, maybe not the best course of action. So therefore we look at the alternatives, which is documenting something.
Right.
So then I think, this is easy. I can just use Chat GPT, or I can go online and get an online provider and just generate. So in the case of, you and I going to business together, we might say, let's get a shareholders agreement done as an example. And so I just go online and get a generic shareholders agreement, tick the boxes on the things, and in 15 minutes, there we go, got an agreement. We both sign it. Happy days.
Perfect.
Yep.
Absolutely perfect. So we had a case like this just yesterday where a fellow had done exactly that to set up a family trust. It turned out that it didn't have an appointor.
Right.
And the problem with that is that he needed to change the trustee, and the appointor had to agree, but there was no appointor. So that's a bit of an issue because it's an urgent situation involving somebody being overseas. They've got a tax issue in terms of capital gains tax, and they need to move within a period of time after they've moved. And the fellow said, maybe I got this online, this deed. And how would I know? All I know is it's pretty difficult to get yourself out of a jam when you've got no weapons. You've got nothing to use because there's just been a shocking oversight.
Yeah.
Now, that's not just with commercial documents, although people use commercial documents regularly from somewhere else. I've got one here, I've got one there. Another client I spoke to yesterday said exactly the same thing. He's going into business, bringing somebody into the company that operates the business, and they'll be 50-50 shareholders. And the other bloke said, well, we'll just use something off the shelf. And our client, long-standing client, said, well, I've got plenty of those, but we want somebody to actually look at this properly.
Yeah.
Because it's going to be a long-term arrangement if we get it right. And if we don't, well, let's not do it.
Yeah. Yeah. So we talked about verbal challenges. We talked about off-the-shelf template type document. So what is the right course of action?
Well,
so, for instance, with a shareholders agreement.
Yeah, understand. But let's just go back to off the shelf. And you'll probably know that people make wills that they might buy they're almost a supermarket these days, online, in a news agency. Now, the greatest source in long experience of disputes in relation to estates is those sorts of wills.
Right.
Handmade wills, where the person making them thinks, well, this is easy. And it's always simple, isn't it? I just want to do this, and I'll just write it down. So, of course, it comes to court, and the court says, well, there is a law in this country, and we've got to comply with it. So let's get it right. And that one, we've had a look at it, doesn't quite measure up. So that's okay, and, well, sort of okay in where everybody's going to agree. You just need the court to support it. But what if there's confusion?
Yeah, and you have to go through that process too, because you said if the court approves it, so you've got to go through that legal process.
Yeah.
And that's costly in these
Just by
circumstances.
itself.
So saving money on an online will or an online document can have major consequences. There is a dispute in some form or some vagaries in that agreement down the track, because you then have to engage lawyers to fix it.
Yeah. And so instead of talking a handful of dollars, really, a few $1,000s, you then start looking at six figures.
Yeah.
And a long time. Litigation can go on for years.
Yeah.
And you don't know what the result's going to be, where there's a dispute. And it's sort of odd because if the person making the will, in that case, is trying to save the beneficiaries from money because that's really going to save them ultimately a few $1,000s, obviously that's not going to work.
No.
So it's really short-sighted and quite ineffective. But when it happens in the commercial context, that's when the real problems occur. So you have seen many times where documents are not up to scratch.
Yes.
Plenty of time. I mean, you'd see this all the time.
I do.
And the fact is you've got to go and backfill if everybody still agrees.
Yeah. Yeah. And that's a challenge because, again, as you said to start with, that things might be, the relationships between the parties might be in a particular way at the start, but then down the track, and you have to backfill, then people's opinions of each other or circumstances may have changed, which means it's hard to then rectify those deficiencies.
Yeah. And often it comes up when the relationship's broken down.
Exactly.
That's when you start looking at these documents and say, well, what are we going to do here? And you realise you need someone else's approval.
Yeah.
And it's not there. So that's when you're in the hole. That's when you've got a big mess.
Yeah.
So when a company or a business strikes a problem like that, the hole is so deep it can imperil the operation completely.
Yeah.
Because it takes the focus away. I mean, ideally, you're supposed to be getting your strategy right, spending your resources on that priority or this priority. You've worked them out, but you're distracted. I mean, one of our taglines is we help you sleep at night.
Yeah, absolutely.
And how do you sleep at night when you've got that buzzing around in your head?
Yeah, yeah. So the challenge, I think, with a lot of businesses, particularly startup businesses, is capital.
Yeah.
And the money required to set up, establish a business, working capital to run the business in the short term. So they're less inclined to want to spend money on documents such as shareholders agreements, etc.
Yeah.
But from what you're saying, you've got to put aside money for that at the start as best you can to make sure you've got a robust agreement at the start so that we're not trying to backfill down the track when circumstances may have changed.
Yeah, absolutely. You've got, the issue is when you, and we know how this happens, you might spend a little a little bit.
You can do that again.
I'm thumping the table here to pay the bond on the lease of the premises. So you're in for that much.
Yes.
And you're going to buy some equipment and you might employ some staff and you're in for that much.
Yes.
And you say, well, look, I'm running out of dough. I can't afford to document this properly. So I'll keep going.
Yes.
So why wouldn't you? I mean, we know the better answer to this, why you must go and get proper advice, do your budgets up front, allow for proper coverage, make sure the thing's properly structured, that you've got insurances in place.
Yes.
And why isn't legal advice proper insurance? It has to be.
Oh, it is. That's what it is. That's how I see it. I see it as an insurance policy in part. Yeah.
And the reason for that is it's actually backed by insurance from a commercial point of view.
Yes.
So the lawyer mucks it up. You sue the lawyer, you get your money back.
Yes.
And whatever damage has been caused, that's insurance.
Yeah.
So, I mean, that's on the negative side, but the positive side is there'll be a lot of questions raised in that process that you may not have thought about it, likely haven't, and we'll actually continue to test the question, should I go ahead with this? How should I do it? How should we do it? And the best way to do it is to have lawyers and accountants working together with the client at the same time.
Yeah. And it's not just, so we're talking about shareholders agreements here, and we haven't elaborated in terms of what they include.
Not there yet.
No, not there yet. But it's not just shareholders agreement. There's a whole raft of other things that need to be looked at, particularly if you're setting up a new business. There's shareholders agreement, clearly. There is employment agreements for your team if you're employing people, as you talked about before. Terms of trade is also very important. And then if you're raising funds through capital or through banks or whatever the case may be, it's then looking at those financial agreements as well. So and I'm probably just scratching the surface. There's probably a lot more things as well. Asset protection, a whole raft of things. So again, it's a matter of looking at not just these particular agreements or requirements in isolation. You've got to look at the whole picture with what you're doing here. And yes, again, allocating resources, appropriate resources to get those things done as early as possible really helps from a risk mitigation point of view going forward, as an insurance policy going forward.
Yeah. Well, the way to think about it is, wouldn't it be great if you knew what the end was before you started?
Yeah, it would be great. I don't think anyone can predict that. Yes,
but you've still got an idea. So we always ask somebody, what's your exit strategy?
Yes.
Up front.
Yes.
And they might say, well, we actually think there's a market here for this. And we can see how it might combine with something else, and we'll end up in this situation. I mean, it could be simply a family business getting small, but then the next generation comes in and they're saying, well, that's
succession is important.
Critical time.
Yes.
But whatever it is, we know that at some stage you're going to have auditors crawling all over the business in due diligence.
Yes.
So you get your thinking right, you get your habits as they should be, and you go on as you begin to, as you intend to finish. So it is far more efficient to be going ahead according to the plan, managing the milestones efficiently, assessing it, going on, rather than coming along with a broom and tidying up mistakes and errors on the way through.
Yeah.
Because we know that that's inefficient, wasteful, and quite often disastrous. And in fact, why most businesses fail in the first few years.
Yes. Yeah.
What are the stats?
Look, I don't know off the top of my head, but it's very high. Number of businesses
up
that fail.
90%.
It can be. Yeah, it can be.
4 out of 5 are going to fail. So they might say, well, why would I spend more money on legal fees if I'm going to fail anyway? Well, they don't think that. They think I'm going to succeed, and then they fail.
Yes.
So get it right.
Yeah. And with these agreements, so we talked about different types of agreements. There's also intellectual property that needs to be considered as well if you're building a brand. So one of the key things you said before is about knowing what the exit plan is. So that's one of the key things that the lawyer does want to know when you're engaging with the clients, what the exit plan is, because that can have a number of ramifications, timing and making sure all the different parties involved in the business, the shareholders, are aligned in that too. Yeah. And that can be a challenge. So let's go to a shareholders agreement. So with the shareholders agreement, what are the key aspects of that you need to think about?
Well, again, let's go.
Yeah.
Start with the end in mind. What's the exit strategy?
Yes.
Why wouldn't that be there? So if they can't agree on that, then you've got to consider whether they should be doing it at all.
Yep.
Because one of them might say, this is going to float. The other one says, I just want it for my kids. I mean, they're major questions.
Yes.
And unless they're raised at the outset, you could be going along in tandem but not ever having any synergy.
Yes.
And the business is actually, for that reason, going to struggle
Yes.
and not reach its potential. So if you've got an end in mind, whatever it is, and it might be, let's say, it is going to be for long-term internal succession because it's particularly it's important to the humanity of the people finding it or founding it, pardon me.
Yes.
Then you say, okay, we've got this business idea, we're going to have this type of support by way of staff. So who's going to make those decisions? Are we going to have a managing director? So what's the governance structure? Do you have people on the board that aren't working in the business or are only working in the business? What's the qualification for admission? What's the qualification for shareholding? What we've got now is you've worked out what your board might look like and what the board's obligation is, because some boards don't even have any writing instructions, and that is likely to be strategy, appointing the CEO and making sure the valuation sticks, and you monitor that. It might be that simple.
Yeah.
So
just on that with valuation, so that's encompassed in the shareholder agreement in terms of striking a valuation.
Yeah.
And that can be done in a number of different ways.
Indeed.
Yeah.
And you've got to work out what those ways are.
Right.
And who the arbiter is if you can't agree, because you need to cover insurance, life insurance, TPD.
Or suddenly exits from the business from a particular shareholder or
Another way
someone.
of doing it,
Yeah.
Whether it's voluntary, involuntary. So these are all down the track questions that you wouldn't normally expect because everything's rosy in the garden when you kick it off.
Yes.
And we're never going to have a problem. Everyone's going to live forever, going to be healthy and get on together and all do their job.
Yeah.
Even if we haven't said what it is.
Yeah. But that's all doomsday stuff, Peter. We're preparing at the start to fail, it seems. I'm being devil's advocate.
I can tell, Shane. Thanks for reminding me. I mean, you've heard this expression so many times, it bears repeating. You sign it, put it in the drawer, never look at it again.
Yes.
Because you've thought about it. That's why you do it. So you say, okay, we've actually thought this through, and that demonstrates our culture, that we actually plan, we're responsible, and we know because we've discussed it, so we've got proper governance, how to behave.
Yes.
So it's a set of rules. It's about culture. It's about conduct.
Yeah.
And it actually is embedded then into the business long term, into the company long term.
Yeah.
So anybody coming on board is going to understand what those values and attributes are.
Yes.
Because they've been thought through. So it's when you do drive into the cliff, you know what to do.
Yes.
And you know how to avoid it.
Yeah.
So doomsday doesn't have to happen, Shane. It's actually the opposite.
So it sits in that drawer, but it should come out every now and again to have a read and make sure it's still contemporary to your circumstances.
Indeed. And this is the review, the strategic review that requires ongoing monitoring.
Yes.
So we've got, a situation where you might have people kicking a business off, but then they decide to amalgamate another business in. You need to look at it again because there's new equity arrangements, maybe new governance structure. So it needs to be reviewed to make sure that it's always fit for purpose.
Yes.
So that's an important and not necessarily challenging exercise, particularly if you get into the habit of knowing how to do it because you're thinking into the future.
Yes.
And you're managing risk, which is one of the most important things you can do in a business.
Yes. Yeah. And so starting business, we engage the lawyer. So the lawyer is not just there to tick the boxes and ask questions to tick the box to create this document. They're there to actually give you guidance and I suppose the different scenarios or options that you're on. So there's not one size that fits all, obviously, and that's why we're saying not do it off the shelf. So it can be a bespoke document for that particular business.
Indeed. And the relationships that you come to enjoy with clients are ones that develop over time. So the expression know your client is fundamental.
Yes.
So you're not me, I'm not you.
Yes.
The businesses that everybody runs are entirely different. Every individual is an individual and face their own challenges.
Yes.
So everything needs to be fit for purpose. So you wouldn't go around choosing things that aren't going to suit you in your everyday life.
Yes.
So why would you take the risk of getting a business that isn't going to suit the
Yeah.
purpose.
Yeah.
It's got to work properly.
Yeah.
And most importantly, because we're in a world of competition, there's not much point trying to replicate somebody else
no.
because you want to actually be able to compete effectively
And differentiate yourself.
with your own special attributes.
Yes, absolutely. Yes. So shareholders agreement talks about different elements within the business. So decision making, exit, so good or bad lever. So if someone's incapacitated, how that's managed, etc. On top of that, you can then link buy-sell type agreements to
Yes.
it. I had a meeting with a prospective client last week, and they'd done a lot of their research, which is great, and it actually made for a really good conversation about shareholders agreement, etc. But then I said to you, have you also thought about a buy-sell agreement to link to that? Because they were young men and they didn't know that was an option. So do you want to expand on buy-sell agreements and what they mean or what they do?
What you're doing is you're providing a facility, normally backed by a third-party funder,
Insurance.
an insurer.
Yes.
If you've got a catastrophe, a health issue,
Mm-hmm.
and one of the founders, one of the participants has to exit the business, you want to be able to make sure that the people staying on can afford to pay out the one that's leaving.
Yes.
Quite often that's not possible from their own resources.
Based on the valuation of the business, based on the shareholders agreement.
Exactly right.
Yes.
So you work out what's the value, you therefore say what's the equity,
Yes.
and the price is the proportion of equity compared to the total value. It may say that you don't have to pay it for a period of time. You agree that in advance.
So vendor terms of some form.
Yep.
Yes.
And it may say that we've got a mechanism in place to fund it, given the type of the catalyst for the exit. So if it's a death or a disability, then that is enough to trigger an insurance policy.
Mm-hmm.
The person receiving the benefit of that insurance policy, whether it's the deceased estate or the exiting shareholder, disabled or whatever, or incapacitated, the others continuing have already made sure that's being funded properly.
Yes.
So the thing can go on, and indeed they may have another policy in place as well called a key person policy.
Yes.
To actually replace the person.
Yes.
That's not able to work.
Mm.
So they are very important and are more important at different stages of the business and the circumstances of and the value of the equity at the time.
Yes. So it's very important, one, to look at the shareholders agreement and the valuation methodology, and whether that's a formula based on earnings of the business or some other calculation or an independent valuation, whatever it might be, and then understanding what that number is for the purpose of if a catastrophic event was to occur, how the business is going to facilitate the exit of that person.
That's right.
Yes.
Yeah. And then it can be, in some cases, tied up with superannuation. So then you need to make sure the people advising are all across what's going on and they're all talking to each other.
Yes.
So there's a proper, efficient process. I've had a situation once where somebody didn't have a shareholders agreement and there was a payout to the deceased's. These two fellows had been in business for 30 or so years. One of them died. They had a policy in place, but they didn't have a buy-sell agreement. So the poor bloke who was left to run the business, having lost his long-term business partner, also had to deal with the family of the partner, and that took some negotiating.
Because there was no mechanism to transfer the shares linked to that insurance policy.
Yeah.
Yes.
So there's still an obligation to pay. And so we had to reconstruct the thing, and it had to go to court. It settled before it went to a judge.
Yes.
But it took about 2 years to do.
Yeah, that would have been costly and had a major
horrible.
impact on
It was really
the business.
horrible.
Yes. So with the buy-sell agreement, it goes hand in hand with the shareholders agreement. Is that correct?
Yeah, and it can be the same thing.
Okay, so you can incorporate them both into the one agreement. Okay, yeah, that makes sense. And with the insurance that's linked to it, it's really important to get that structured correctly. And that's, I suppose, a bit of my space in terms of making sure from a taxation point of view that is the policy is in the correct names and has the right outcome to avoid it being there's potential for that insurance proceeds to be non-taxable. Having said that, transfer of equity could be still taxable. And so we need to consider, one, the insurance policy proceeds, and then secondly, the transfer of equity and how that might impact them from a capital gains tax point of view.
That's exactly right. So that you need the collaboration.
Yes, yes.
Now, in some cases, we've actually been setting up trusts to own these insurance policies.
Yes, yeah.
And the reason for that is that if you've got a big business with a lot of partners, which you can have, you don't want all the partners to have to sign the partnership agreement. I mean, partnership agreements sound a bit odd these days, but there are still some businesses that have to have partnerships.
Yes.
So you can't have all the partners signing on all the time every time there's a change. So you've got to have these mechanisms to be able to manage the whole thing as if it was one entity. And so you can have subtleties about all of this. But again, that can be a really effective, very efficient way of operating. And until we did it in that particular example, they had a real problem.
Yes.
So it was a terrific solution to be able to come up with that type of response.
Yes.
Yeah.
Yeah. And with which I've been saying, shareholders agreement, but that could be interchanged with partnership agreement, unit holders agreement.
Yep.
Any other terms that joint venture agreement, similar?
Well, JVs can be venture specific, special purpose vehicles.
Yes.
But they're all the same sort of things. They're all to do with people dealing with each other for commercial purposes.
It's just the different structures in place and therefore different names for the agreements in effect.
But the same ingredients.
Yes.
You've still got to work out how to end it. What do you do on the way through? How do you fund it?
Yep.
What are the obligations? What if somebody kicks in some money and the other ones don't?
Yep.
What sort of compensation do they get? What securities do they get? All of these things. You can't just do it and then say, well, I thought it was going to be secured or I was going to get my money back first.
Yes.
And then find out, well, who said? That's not what you want.
Yeah. And again, we're talking about focusing a lot on exit strategies or exit events. And we talked about buy-sell agreements, talked about shareholders agreements. If the insurance is not enough to cover, which you talked about before, if insurance is not enough to cover, because it's cost prohibitive because of the age of the people or circumstances, how do we manage that part if the insurance is not enough to cover, or there's an event that doesn't trigger insurance proceeds? How do we manage that part?
Well, you've got a couple of ways. One of them is forward planning. But you might say we're all here for the long term, provided our health stands up.
Yes.
And if somebody wants to leave, well, then there's a question about how much they get of their value. So if somebody wants to leave unexpectedly, what's the deal? And the good thing for me, when you're drafting these agreements is you're not pointing the finger at one or the other. That's a really useful position to be in.
Yes.
Because it's not about the individual. It's about the business. The business is the hero. Let's get the business, keep the business safe, get it right, make sure it's able to continue operating. So no matter who does this, commits that particular act by leaving early because they want to go surfing or around the world or whatever, or fallen in love again or whatever it is, the consequence of that is already set down. You could give notice, give us 12 months notice. That might help. Give us 12 months notice and you get this proportion of your value.
Yes.
But not all of it. Or whatever. But it gives you need notice because a business needs time for continuity, and it can sort things out over a time frame. Like it might bring in another replacement equity holder with the same sort of skill base or whatever. But the shareholders agreement will give the parties the scope to be able to work through those scenarios and manage them so the business can be as well maintained as possible without damaging it, without damaging the brand, and without causing some sort of massive
cash flow strain or otherwise because the funding of that exiting partner becomes prohibitive. Yeah.
Well, that wouldn't necessarily come from the business though, would it?
No, true.
So again, you've got to work out where this is all coming from.
Yeah.
So in a shareholders agreement, typically you say that there might be an ability for a company buyback, a share buyback, or it may be that the other people offer, it could be a third party offer, but then who's going to approve that? You don't want to be finding yourself in business one day with these people and then all of a sudden somebody's told you, here's your new shareholder.
Yes.
And you don't like them.
Yes.
All of these things can happen.
But again, the provisions of the agreement can put limits or restrictions on those types of events occurring because first right of refusal for the existing shareholders or whatever it might be.
Gives you a process.
Yeah.
And of course, the what if in these cases is if it's not sorted, guess where you have to go? Off to the Supreme Court.
Yes.
Or the Federal Court. Either way, it's no good. It's no good. It's the absolutely worst option.
Yes.
So that you talked about cash flow. Guess what that's going to do to your cash flow?
Yeah, dramatically
Yeah.
affect it. Yeah.
Yeah.
So with so in effect you can have vendor terms within the agreement.
Yes.
One of the things, just trying to expand on that, is that if you've got a person leaving, and the agreement is such that they follow the steps of the shareholders agreement, the equity transfers potentially at day one. What I'm trying to get to is that when someone says, I'm putting my hand up and I want to leave, we then follow the shareholders agreement, and it gives a mechanism of how that share transfer occurs, or that unit holding occurs, whatever it might be. The person who is staying in the business who acquires those shares can use the future profits of that equity they're acquiring to then help them with the funding of the exiting partner,
If that's the way it's set up.
if there's reasonable vendor terms on the agreement.
But
which gives them
again,
time
that's
to
got
pay.
to be thought through.
Yeah.
So you say who's got the equity
Yes.
and what's the basis upon which the dividends, how do the dividends work?
Yeah. Yeah.
And that's another variable.
Yeah. So I suppose what we're getting to on all this, it's not cookie cutter. It's
No.
not straightforward. And this is where it's really critical that as soon as possible and as early as possible, lawyers are engaged if there's different parties to to a business, that the shareholders agreement and these other documents we talked about briefly, and we'll cover those in probably later podcasts. It's important that those things are done early and those issues are identified early, and you engage with your lawyer to make sure you get an agreement in place that suits the circumstances of the people and the parties to this business.
Yeah. Well, I had a client contact me earlier today saying, we saw you recently about this requirement, and it's a good thing we're getting your newsletters because they're reminding us of these things, but we need to do it now. And I said, we last spoke in 2024. Oh, was it that long ago? So these things can slip by if you don't deal with them.
Yes.
Because you've always got something pressing. There's always another thing.
Yes.
So what's your real priority? Do you want something to be safe, strong, substantial, and enduring, or not?
Yes. Yeah. And I think the other message from this too is that sometimes lawyers are seen as it's a transaction with a lawyer. You engage them to do a specific task, and then that task is done, and then thanks very much. And then when another task comes up down the track, you then might engage them again. But what you're saying or suggesting, I think, is that your lawyer should, like an accountant where you see them every year or whatever the case may be, or more regularly, you should also have the same philosophy with your lawyer, and making sure your lawyer is across all your activities and giving you, even if it's just a quick briefing every 3-6 months, whatever it might be, that they're across what's going on with your business so that they can then advise you if there's things that might be relevant to them at that time.
That's
so it's
right.
not just a transaction thing and then see you later down the track, whenever that may be. Like this case, I haven't seen you for 2 years.
Yeah.
You should be in constant contact with your lawyer as well.
Well, that's right. And then the other thing goes to governance of say, more substantial or established businesses where you may actually have the lawyer / or the accountant coming along to the board meetings every so often.
Yes.
For a proper briefing and a feedback session and some advice, or have them together.
Yes.
Because that way you're getting advice at the source when you need it, and you're giving those advisors a fighting chance. When they don't know what's going on, how can they give you proper advice? How can you get the value out of the advice and the experience that they've obviously got?
Yes, absolutely. Yeah, no, it's fantastic. Great advice. That'll probably do us for today, Peter. So thank you very much for your insights. I found it very informative, and I hope the audience did as well. So thank you everyone for joining us today in our episode of Plant, Grow, Reap. The next episode in our series on what your lawyer wants you to know will be on estate planning and what your lawyer wishes you knew about wills and protecting your family and business legacy. So look out for that one shortly. Thank you.